And we're back. We're back. Honey, give me a thumbs up if you can hear me. Child, this is the hell. I keep naming my damn strangely. I keep naming my behavior after R. Kelly tours. Ain't don't he ever didn't he have a tour called a double up tour? Oh, yes, thank you. Red Bunny got it right. I looked up and she had the thumbs up in there. What's good with it, Mac Dime? Hey, sweet Mac Dime. Hey, Red Bunny. Shout hey. Shout hey. Cool BJ, what's good with it? Lavelle Marshall, what's going on with it, sir? What's going on with it? Please make sure if y'all sitting out there and looking in the window, hit that like button, share, and subscribe. Yes, so the paper, did I tell you the paperwork will begin to fly out the door? We have to put them in the book, honey. We have to put it in the book. So, and I'm trying to get to my messages or whatever. You know, I'm gonna get right into it, but I just want to make this clear. Um, if you leave me a message that is slick in nature, you are going to get a slick response. And sometimes I don't even get to read in all of it because I be so quick to want to cuss your ass out. I don't even get down to through it all. You know what I'm saying? But I'm gonna try to provide better customer service in that because I know that a lot of people are stuck in their emotions. But when you say something to me that is very apparent untrue, I'm probably not going to consider your emotions, right? So whoever that person that just left that message on there saying that uh do I ever get do I get when I'm reading something positive, do I get excited or something like that? Apparently, you didn't listen to the live. Well, you had to listen to the live because you left a message talking about the live. You saw I was excited when the shit was positive. It don't matter who it's for. My excitement be about the law and the different skill sets that these people employ, right? No matter what side. I don't give a fuck what side it is. Because I don't have one. But as you see, I was very excited. I'm very excited for Miss Judge. Okay? Milton Brown's attorney. I'm very excited for when any side gets something right or they catch something or something like that, or especially if they confirm some shit I don't call shit. Well, I don't give a damn what side it's on. I really don't. So please don't leave me no stupid message because you caught up in your feelings. All right? I didn't pay for your feelings, so I don't expect for them to spill over here. I don't give a damn about no feelings. I can give less than a damn what I'm reading, who it favors. If I feel like it's good, hey, and if it's a good catch, I'm gonna get excited about it. I get excited about shit. Sometimes I don't. Okay? So don't act nothing stupid. When I start off my last live, I told you Thursday, Friday, Saturday, Sunday, and Monday. I'm not fucking around with y'all. So leave me alone. Now, we're gonna see what we can. I'm not on around the front, so we're gonna see if we can find out anything, with if we can get any glimpse of what the case may entails or whatever by looking at this proposed jury instructions, right? Also known as a jury charge. Okay, this is the government's proposed. Right? Now I'm gonna tell you, if J Bo drops hers tonight, probably not gonna be on him. Okay? I'm just letting you know because I'm getting kind of sleepy. So let's see what we got. It says government's proposed jury instructions. Okay. The United States of America, by its attorney John R. Losh Jr., United States Attorney for the Northern District of Illinois, hereby submits the government's proposed instructions and verdict forms for this case. Because the government based this submission on the anticipated trial evidence, the government may ask this court for permission to supplement or modify these proposed jury instructions as appropriate. So, hopefully we'll be able to get something out of this, right? The members of the jury, I will now instruct you on the law that you must follow in deciding this case. Each of you has a copy of these instructions to use in the jury room. You must follow all of my instructions about the law, even if you disagree with them. This includes the instructions I gave you before the trial, any instructions I gave you during the trial, and the instructions I am giving you now. As jurors, you have two duties. Your first duty is to decide the facts from the evidence that you saw and heard here in the court. This is your job, not my job or anyone else's job. Your second duty is to take the law as I give it to you, apply it to the facts, and decide if the government has proved the defendant guilty beyond a reasonable doubt. You must perform these duties fairly and impartially. Do not let sympathy, prejudice, fear, or public opinion influence you. In addition, do not let any person's race, color, religion, national ancestry, or gender influence you. You must not take anything I said or did during the trial as indicating that I have an opinion about the evidence or about what I think your verdict should be. The charges against the defendant are in a document called an indictment. You will have a copy of the indictment during your deliberations. The indictment in this case charges defendant Robert Kelly with sexual exploitation of a minor, conspiring to obstruct justice, conspiring to receive child pornography, receipt of child pornography, and enticement of minors to engage in unlawful sexual conduct. Defendant Daryl McDavid is charged with conspiring to obstruct justice, conspiring to receive child pornography, and receipt of child pornography. Defendant Milton Brown is charged with conspiring to receive child pornography. The defendants have pled not guilty to the charges. The indictment is simply the formal way of telling a defendant what crimes he is accused of committing. It is not evidence that the defendant is guilty. It does not even raise a suspicion of guilt. Each defendant is presumed innocent of each and every one of the charges. This presumption continues throughout this case, including during your deliberations. It is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the particular defendant you are considering is guilty as charged. The government has the burden of proving each defendant's guilt beyond a reasonable doubt. This burden of proof stays with the government throughout the case. A defendant is never required to prove his innocence. He is not required to produce any evidence at all. You must make your decision based only on the evidence that you saw and heard here in court. Do not consider anything you may have seen or heard outside of the court, including anything from the newspaper, television, radio, the internet, or any other source. The evidence includes only what the witnesses said when they were testifying under oath, the exhibits that I allow into evidence, and the stipulations that the lawyers agreed to. A stipulation is an agreement that certain facts are true or that a witness would have given certain testimony. Nothing else is evidence. The lawyer's statements and arguments are not evidence. If what a lawyer said is different from the evidence as you remember it, the evidence is what counts. The lawyer's questions and objections likewise are not evidence. A lawyer has a duty to object if the lawyer thinks a question is improper. If I sustain the objections to the questions the lawyer asked, you must not speculate on what the answer might have been. If during the trial I struck testimony or exhibits from the record or told you to disregard something, you must not consider it. Give the evidence whatever weight you believe it deserves. Use your common sense in weighing the evidence and consider the evidence in light of your own everyday experience. People sometimes look at one fact and conclude from it that another fact exists. This is called an inference. You are allowed to make reasonable inferences so long as they are based on the evidence. You may have heard the terms direct evidence and circumstantial evidence. Direct evidence is evidence that directly proves a fact. Circumstantial evidence is evidence that indirectly proves a fact. You are to consider both direct and circumstantial evidence. The law does not say that one is better than the other. It is up to you to decide how much weight to give to any evidence, whether direct or circumstantial. Part of your job as jurors is to decide how believable each witness was and how much weight to give each witness' testimony, including that of a defendant. You may accept all of what a witness says, or part of it, or none of it. Some factors you may consider include the age of the witness, the intelligence of the witness, the witness's ability and opportunity to see, hear, or know the things the witness testified about, the witness memory, the witness demeanor, whether the witness had any bias, prejudice, or other reason to lie or slant the testimony, the truthfulness and accuracy of the witness testimony in light of other evidence presented, and inconsistent or consistent statements or conduct by the witness. Do not make any decisions simply by counting the number of witnesses who testified about a certain point. You may find the testimony of one witness or a few witnesses more persuasive than the testimony of a larger number. You need not accept the testimony of the larger number of witnesses. What is important is how truthful and accurate the witnesses were and how much weight you think their testimony deserves. A defendant has an absolute right not to testify or present evidence. You may not consider in any way the fact that a defendant did not testify or present evidence. You should not even discuss it in your deliberations. You may consider evidence that the defendant was convicted of a crime only in deciding the believability of his testimony. You may not consider it for any other purpose. The other convictions are not evidence of whether the defendant is guilty of any crime he is charged with in this case. You have heard a witness who gave testimony regarding. You do not have to accept this witness testimony. You should judge this witness testimony the same way you judge the testimony of any other witness. In deciding how much weight to give to this testimony, you should consider the witness's qualifications, how he reached his conclusions, and the factors I have described for determining the believability of testimony. You should not speculate why any other person whose name you may have heard during this trial is not currently on trial before you. It is proper for an attorney to interview any witness in preparation for trial. You have heard a recorded conversation and seen video recordings. This is proper evidence that you should consider together with and in the same way you consider the other evidence. You were also given transcripts of the conversations on the recordings to help you follow the recordings as you listen to them. The recordings are the evidence of what was said and who said it. The transcripts are not evidence. If you notice any differences between what you heard in a conversation and what you read in the transcripts, your understanding of the recording is what matters. In other words, you must rely on what you heard, not what you read. And if you could not hear or understand certain parts of a recording, you must ignore the transcripts as far as those parts are concerned. I am providing you with the recordings and a device with instructions on its use. It is up to you to decide whether to listen to the a recording during your deliberations. You may, if you wish, rely on your recollections of what you heard during the trial. If during your deliberations you wish to have another opportunity to view A. Any transcripts as you listen to a recording, send a written message to the marshal, court security officer, and I will provide you with the transcripts. Certain summaries charts were admitted into evidence. You may use those summaries charts as evidence, even though the underlying documents evidence are not here. The accuracy of the summary charts has been challenged. The underlying documents evidence has have also been admitted so that you may determine whether the summary charts are accurate. It is up to you to decide how much weight to give the summary charts. Certain summary charts were shown to you to help explain other evidence that was admitted, specifically identify the demonstrative exhibit if appropriate. These summary charts are not themselves evidence or proof of any facts, so you will not have these particular summary charts during your deliberations. If they do not correctly reflect the facts shown by the evidence, you should disregard the summary charts and determine the facts from the underlying evidence. If you have taken notes during the trial, you may use them during deliberations to help you remember what happened during the trial. You should use your notes only as aids to your memory. The notes are not evidence. All of you should rely on your independent recollection of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any more weight than the memory or impressions of each juror. Consideration of the charges. Even though the defendants are being tried together, you must consider each defendant and the evidence concerning that defendant separately. Your decision concerning one defendant, whether it is guilty or not guilty, should not influence your decision concerning any other defendant. Defendants Robert Kelly and Darrell McDavid have each been accused of more than one crime. The number of charges is not evidence or of guilt and should not influence your decision. You must consider each charge separately. Your decision on one charge, whether it is guilty or not guilty, should not influence your decision on any other charge. The indictment charges that the crimes happened on or about certain dates. The government must prove that the crimes happened reasonably close to those dates. See? See what I'm talking about? See, they don't come in here with the shit now. They remember I said about the dates and the be exact and all of this or whatever. See how they put it? Let me reread it because we talked about that kind of extensively. The indictment charges that the crimes happened on or about certain dates. The government must prove that the crimes happened reasonably close to those dates. The government is not required to prove that the crimes happened on those exact dates. Terms applicable to multiple counts. Some of the charges contained in the same some of the charges contain the same terms. I will define for you now some of those terms. I will give you in later instructions additional definitions for terms that are applicable to specific charges. Knowingly. A person acts knowingly if he realizes what he is doing and is aware of the nature of his conduct and does not act through ignorance, mistake, or accident. In deciding whether a defendant acted knowingly, you may consider all of the evidence, including what the defendant did or said. Minor means any person under the age of 18 years. Child pornography means a visual depiction of sexually explicit conduct, including any photograph, film, video, or picture, whether made or produced by electronic, mechanic, or other means, if the production of the visual depiction involved the use of minor engaged in sexually explicit conduct. Visual depiction includes any video, whether made or produced by electronic, mechanic, or other means. Sexually explicit conduct includes 1. Actual or simulated sexual intercourse, including genital to genital, oral genital, anal genital, or oral anal. Number 2, masturbation. Number 3, sadistic or masochistic abuse. Or number 4, lascivious exhibition of the anus, genitals, or pubic area of any person. Um, lascivious. Why can I never say that word? Um, lascivious exhibition is a display that calls attention to the genitals or pubic area for the purpose of eliciting a sexual response in the viewer. Coerce means 1. Using threats of serious harm to or physical restraint against any person. 2. Any scheme, plan, or pattern intended to cause a person to believe that failure to perform an act would result in serious harm or to physical restraint against any person. Or 3. The abuse or threatened abuse of law or the legal process. Serious harm means any harm, whether physical or non physical, including psychological, financial, or reputational harm that is sufficiently serious under the circumstances to compel a reasonable person of the same background and in the same circumstances to perform or to continue performing sexual activity in order to avoid incurring that harm. Interstate commerce means commerce between different states, territories, and possessions of the United States, including the District of Columbia. Images and video transmitted or received over the internet have moved using a means of facility of interstate or foreign commerce. It is for you to determine, however, if the material containing the visual depiction had been transmitted or received over the internet. Foreign commerce means commerce between any state, territory, or possession of the United States and a foreign country. Commerce includes, among other things, travel, trade, transportation, and communication. Specific counts. I would now describe to you the specific charges in the indictment and what is required to prove each of those charges. Sexual exploitation of a minor 1. Counts 1, 2, 3, and 4. Defendant Robert Kelly. Counts 1, 2, 3, and 4 of the indictment charge defendant Robert Kelly with sexual exploitation of minor 1. In order for you to find the defendant guilty of this charge, the government must prove each of the following 3 elements beyond a reasonable doubt. So here come the elements, y'all. Okay? Number 1, at the time, minor 1 was under the age of 18. Number 2, the defendant, for the purpose of producing a visual depiction of such conduct, employed, used, persuaded, or coerced minor 1 to take part in sexually explicit conduct in the manner described in the particular count you are considering. And 3, the visual depiction was mailed or actually transported across state lines or in foreign commerce. If you find from your consideration of all of the evidence that the government has proved each of these elements beyond a reasonable doubt as to the particular count you are considering, then you should find the defendant guilty of that count. If on the other hand, you find from your consideration of all the evidence that the government has failed to prove any of these elements beyond a reasonable doubt as to the particular count you are considering, then you should find the defendant not guilty of that count. Conspiracy counts, general instructions. Counts 5 and 6 of the indictment charge certain defendants with the offense of conspiracy. The following general instructions about conspiracy are applicable to both conspiracy counts. A. A conspiracy is an express or implied agreement between two or more persons to commit a crime. A conspiracy may be proven even if its goal were not accomplished. In deciding whether the charged conspiracy existed, you must consider all of the circumstances, including the words and acts of each of the alleged participants. To be a member of a conspiracy, a defendant does not need to join it at the beginning, and he does not need to know all of the other members or all of the means by which the illegal goals of the conspiracy were to be accomplished. The government must prove beyond a reasonable doubt that the defendant you are considering was aware of the illegal goals of the conspiracy and knowingly joined the conspiracy. A defendant is not a member of a conspiracy just because he knew and or associated with the people who were involved in a conspiracy, knew there was a conspiracy, or was present during conspiratorial discussions. In deciding whether a defendant joined the charged conspiracy, you must base your decision only on what the defendant did or said. To determine what that defendant did or said, you may consider that defendant's own words or acts. You may also use the words or acts of other persons to help you decide what the defendant did or said. The government need not prove that a defendant was aware of or played a role in every act of the conspiracy, or that the defendant knew every member of the conspiracy. Instead, the evidence need only to show that the defendant was aware of the aim of the conspiracy and made a knowing decision to join it. Conspiracy to obstruct justice. Count 5. Defendants Robert Kelly and Daryl McDavid. Count 5 of the indictment charges defendant Robert Kelly and Daryl McDavid with the conspiracy to obstruct justice. In order for you to find a defendant guilty of this charge, the government must prove each of the following three elements beyond a reasonable doubt. 1. The conspiracy as charged in count 5 existed. 2. The defendant knowingly became a member of the conspiracy with an intent to advance the conspiracy. And 3. One of the conspirators committed an overt act in an effort to advance the goals of the conspiracy. An overt act is any act done to carry out the goals of the conspiracy. The government is not required to prove all of the overt acts charged in the indictment. The overt act may itself be a lawful act. If you find from your consideration of all of the evidence that the government has proved each of these elements beyond a reasonable doubt as to the particular defendant you are considering, then you should find that defendant guilty. If, on the other hand, if you find from your consideration of all of the evidence that the government has failed to prove any of these elements beyond a reasonable doubt as to the particular defendant you are considering, then you should find that defendant not guilty. Count 5 charges a conspiracy to commit the offense of obstruction of justice. The offense of obstruction of justice is committed when 1. A person knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object. 2. A person acts with the intent to impede, obstruct, or influence an investigation or proper administration of any matter. And 3. The investigation or matter is within the jurisdiction of an agency of the United States. For purposes of count 5, a tangible object is an object that can be used to record or preserve information. An agency of the United States includes Homeland Security Investigations, or HSI. An investigation regarding child pornography is a matter within the jurisdiction of that agency. An investigation or matter within the jurisdiction of an agency of the United States need not have been pending or imminent at the time of the conduct. It is sufficient that the act was done in contemplation of or in relation to a matter or investigation that is within the jurisdiction of a federal agency. Okay, let me read this. There's a reference here. It says, is meant to apply broadly to any acts to destroy, fabricate physical evidence, so long as they are done with the intent to obstruct, impede, or influence the investigation or proper administration of any matter, and such matter is within the jurisdiction of an agency of the United States, or such acts done either in retaliation or in contemplation of such a matter or investigation. This statute is specifically meant not to include any technical requirement, which some courts have read into other obstruction of justice statutes, to tie the obstructive conduct to a pending or imminent proceeding or matter. It is also sufficient that the act is done in contemplation of or in relation to a matter or investigation. It is also meant to do away with the distinctions which some courts have read into obstruction statutes between court proceedings, investigations, regular or administrative proceedings, whether formal or not, and less formal government inquiries regarding of their title. Destroying or falsifying documents to obstruct any of these types of matters or investigations, which in fact are proved to be within the jurisdiction of any federal agency, are covered by this statute. Questions of criminal intent are, as in all cases, appropriately decided by a jury on a case by case basis. It is also extends to acts done in contemplation of such federal matters, so that the timing of each act in relation to the beginning of the matter or investigation is also not a bar to prosecution. The intent of the provision is simple. People should not be destroying, altering, or falsifying documents to obstruct any government function. Count 5 of the indictment alleges that the conspiracy to obstruct justice began in approximately 2000 and continued through February 13th, 2020. God damn. In evaluating the evidence with respect to count 5, you may consider evidence of conduct and events prior to July 11, 2014. However, in order for you to find a defendant guilty of count 5, you must find beyond a reasonable doubt that the defendant was a member of the charged conspiracy, and that on or after July 11, 2014, 1. The charged conspiracy existed or continued to exist, and 2. A co-conspirator committed at least one overt act in furtherance of the conspiracy. Right? Got some more notes down here. All right, this is case law. The Seventh Circuit in 1994, I guess, held the defendant did not violate ex post facto clause, despite fact that what is it? Mecatinon did not appear as Schedule I controlled substance. Oh, I don't know that. I don't know about that dope. Methadone. I don't know. I don't know what that crack shit is. I don't know how to pronounce that. Schedule I, controlled substance, until 8 days after date indictment charge was the beginning of the conspiracy to manufacture the drug. And there's another case law in Second Circuit of 1999 held a conviction for a continuing offense straddling enactment of a statute would not run afoul of the ex post facto clause unless it was possible for the jury to convict exclusively on pre-enactment conduct, and we went over ex post facto pretty extensively. Let's see. The Fifth Circuit of 1984 held that we have held that where a crime is still being carried on and continued after the date when the act becomes effective, a statute imposing a greater penalty for conspiracy does not violate the constitutional prohibition of ex post facto laws. So I guess they're talking about this because remember early on in one of J. Bo's motion, she was, petitioning to the court. Let me see if I can remember something about. Oh yeah, about one of the laws being amended, right? And as we know with ex post facto, like as long as they make a change before that law expires, then the ex post factos, I think the ex post facto does apply because it can go back and be retroactively and all of that. When you are making when they are making, when legislation are making new laws for state and feds, the ex post facto does not apply. Okay. So it says, let's see, 18 USC section 3282A, the statute of limitations for violations of 18 USC section 1519 is 5 years. Okay, so apparently, I guess they're just trying to cover themselves because she was, J-Bo was objecting and raising issues with regards to one of those laws that was amended, and she did raise ex post facto concerns. All right, let's see. It says you have heard testimony that the defendant Robert Kelly was charged in state court with child pornography offenses relating to video one and minor one. He was acquitted of these charges after a state court trial. So, all right, so right there we know that there was a video one and minor one back in the 2008 thing. So that video two, three, and four are must be different videos. I guess that's what we can glean from this. He was acquitted of those charges after a state court trial. The state and federal governments are separate sovereigns. Therefore, the double jeopardy clause of the United States Constitution does not prevent the state and federal government from prosecuting the same defendant on related charges. And if you've been dealing with me since I don't know when, double jeopardy is my soul spot. I want to bust somebody in their goddamn head every time they say it. I done explained it till I'm about dead. So here you go. The people don't explain it to you. The white man. Because you don't listen to the black lady. You listen to the white man. So there you go. Two different songs. Well, I don't want to hear no more about no goddamn double jeopardy. Okay. Let's go. All right. Okay. There's not prosecuting the same defendant on related charges. There is no prohibition against the federal government's prosecution of Robert Kelly in this case. You may consider the fact that Robert Kelly is charged and acquitted in the state court only in deciding, one, whether the charge conspiracy to obstruct justice existed, and two, if you find the conspiracy existed, whether Robert Kelly and or Daryl McDavid knew about the conspiracy and participated in it. You may not consider this evidence for any other purpose, right? So right there is an example of a limiting instruction. Okay. And keep in mind, this is the government's proposed jury instructions that they're offering up to the judge for him to incorporate and combine that along with whatever the defense submits, and the judge will wrap it all up in one and then deliver that charge to the jury, right, when the time comes. All right. Okay, it says the fact that Robert Kelly was charged and acquitted of related charges in state court is not evidence of any defendant's guilt or innocence of the charges in this case. All right, let's read this. Case law. Under this dual sovereignty doctrine, a state may prosecute a defendant under state law even if the federal government has prosecuted him for the same conduct under a federal statute, or the reverse may happen. Case law. The Seventh Circuit in 1985 held that a defendant's prosecution by the United States following his acquittal in state court does not violate the double jeopardy clause. Okay. You have heard evidence that certain witnesses took one or more polygraph tests. You may consider evidence related to the polygraph test only in deciding one, whether the charge a conspiracy. I'm sorry, how they write? Wait a minute, hold on. Let me say. You may consider evidence related to the polygraph test only in deciding one, whether the charge a conspiracy to obstruct justice existed, and two, if you find the conspiracy existed, whether Robert Kelly and or Del McDavid knew about the conspiracy and participated in it. You may not consider this evidence in evaluating the credibility of testimony given by a witness who took a polygraph test or for any other purpose. Another example of limited instruction. Okay. All right. Let's see. This is case law. All right. I guess 1998 plurality agreeing that by its very nature, polygraph evidence may diminish the jury's role in making credibility determinations. Conspiring to receive child pornography. Count 6. Defendants Robert Kelly, Derek McDavid, and Milton Brown. Count 6 of the indictment charges defendant Robert Kelly, Derek McDavid, and Milton Brown with a conspiracy to receive child pornography. In order for you to find a defendant guilty of this charge, the government must prove each of the following elements beyond a reasonable doubt. 1. The conspiracy as charged in count 6 of the indictment existed, and 2. The defendant knowingly became a member of the conspiracy with an intent to advance the conspiracy. If you find from your consideration of all the evidence that the government has proved each of these elements beyond a reasonable doubt as to the particular defendant you are considering, then you should find that defendant guilty. If, on the other hand, if you find from your consideration of all of the evidence that the government has failed to prove any of these elements beyond a reasonable doubt as to the particular defendant you are considering, then you should find that defendant not guilty. Okay? So y'all can kind of get an idea of what they need to prove, right? So if you can remember what they have in discovery, what what alleged evidence they have, you can kind of see, do you think that they'll be able to prove based on those elements, the elements that I'm going through, either defendant guilty, whoever is listed, whatever defendant is listed on the particular charge. Okay. Count 6 of the indictment charges defendants Robert Kelly, Darrell McDavid, and Milton Brown with conspiracy to receive child pornography. The offense of receiving child pornography is committed when 1. A person knowingly receives certain material. 2. The material contains child pornography. 3. The person knew both that the material depicted on one or more minors and that minors were engaged in sexually explicit conduct. And 4. The material was mailed, shipped, or transported in interstate or foreign commerce by any means. Count 7 and 8, receipt of child pornography. Defendants Robert Kelly and Darrell McDavid. Count 7 and 8 charge defendants Robert Kelly and Darrell McDavid with the receipt of child pornography. In order for you to find a defendant guilty of this charge, the defendant must prove each of the following 4 elements beyond a reasonable doubt. 1. The defendant knowingly received the video or videos identified in the particular count you are considering. 2. The video or videos contain child pornography. 3. The defendant knew both that the video or videos depicted a minor and the minor was engaged in sexually explicit conduct. And 4. The video or videos was or were mailed, shipped, or transported in interstate or foreign commerce by any means. If you find from your consideration of all the evidence that the government has proved each of these elements beyond a reasonable doubt as to the particular defendant and count you are considering, then you should find the defendant guilty. If, on the other hand, you find from your consideration of all the evidence that the government has failed to prove any of these elements beyond a reasonable doubt as to the particular defendant and count you are considering, then you should find the defendant not guilty. For purpose of count 6, 7, and 8, in determining whether video 2, 3, or 4 contain a lascivious exhibit of anus, genitals, or public area of any person, you may consider the intent and motivation of the videographer. Any person who knowingly aids, counsels, commands, induces, or procures the commission of an offense may be found guilty of that offense if he knowingly participated in the criminal activity and tried to make it succeed. If a defendant knowingly causes the acts of another, then the defendant is responsible for those acts as though he personally committed them. What did I say? If the defendant knowingly causes the acts of another, then the defendant is responsible for those acts as the oh, okay. You see what they saying now, right? They saying if the defendant knowingly like causes someone to do something, even though they didn't do it themselves personally, they should be held responsible as if they did it themselves. So I wonder where that come into play. What part, who did that? Enticement of a minor, counts 9, 10, 12, 13, defendant Robert Kelly. Counts 9, 10, 12, and 13 charge defendant Robert Kelly with enticement of a minor to engage in sexual activity. In order for you to find the defendant guilty of this charge, the government must prove each of the following 4 elements beyond a reasonable doubt. Number 1, the defendant used a facility or means of interstate commerce to knowingly persuade, induce, entice, or coerce a minor to engage in sexual activity, as charged in counts 9, 10, 12, and 13. Number 2, the minor was less than 18 years of age. Number 3, the defendant believed that the minor was less than 18 years of age. And number 4, if the sexual activity had occurred, the defendant would have committed the criminal offense of aggravated criminal sexual abuse. If you find from your considerations of all the evidence that the government has proved each of these elements beyond a reasonable doubt as to the particular count you are considering, then you should find the defendant guilty of that count. If, on the other hand, if you find from your consideration all the evidence that the government has failed to prove any of these elements beyond a reasonable doubt as to that particular count you are considering, then you should find the defendant not guilty of that count. For purposes of counts 9, 10, 12, and 13, a person commits aggravated criminal sexual abuse if that person commits an act of sexual penetration or sexual conduct with a victim who is at least 13 years of age but under 17 years of age, and the person is at least 5 years older than the victim. So right there, they are adopting the Illinois state law with regards to that, remember? Sexual conduct is defined as any intentional or knowing touching of fondling by the victim or the accused, either directly or through clothing of the sex organs, anus, or breasts of the victim or the accused, or any transfer or transmission of semen by the accused upon any part of the clothed or unclothed body of the victim for the purpose of sexual gratification or arousal of the victim or the accused. Oh, and seeing right there, this is the Illinois law. Okay? So that's what they're using. entice, and when I say that's what they're using, that would be the authority, right? The binding authority. Enticement of a minor, count 11. Defendant Robert Kelly. Count 11 charges defendant Robert Kelly with enticement of a minor to engage in sexual activity. In order for you to find the defendant guilty of this charge, the government must prove each of the following four elements beyond a reasonable doubt. One, the defendant used a facility or means of interstate commerce to knowingly persuade, induce, entice, or coerce a minor to engage in sexual activity as charged in count 11. Number two, the minor was less than 18 years of age. Number three, the defendant believed that the minor was less than 18 years of age. And number four, if the sexual activity had occurred, the defendant would have committed the criminal offense of sexual exploitation of a child. If you find from your consideration of all of the evidence that the government has proved each of the elements beyond a reasonable doubt, then you should find the defendant guilty. If, on the other hand, if you find from your consideration of all the evidence that the government has failed to prove any of these elements beyond a reasonable doubt, then you should find the defendant not guilty. For purposes of count 11, the criminal offense of sexual exploitation of a child requires that a defendant employ, use, persuade, induce, entice, or coerce a minor to engage in sexually explicit conduct for the purpose of producing a visual depiction of such conduct, with knowledge or reason to know that such visual depiction will be transported in interstate or foreign commerce. Hmm. With the knowledge, knowing that. Hmm. That right there might be something that the defense might can challenge, because it says with the knowledge or reason to know that such visual depiction will be transported in interstate or foreign commerce. So you can't, if you're making home movies and videos or whatever for your own personal use, you can't know that it's going to get out and be sold across state lines or what have you. Now, what may be the catch, I only heard this in the New York situation, where he had the book bag and he was carrying the tapes across state lines or whatever. However they were saying he was doing with the tapes and all this shit or whatever. I think that's what I believe, right? So I don't know. It may be a pretty good challenge with that particular verbiage. It says the consent or voluntary participation of a minor is not a defense to the charges stated in counts 9, 10, 11, 12, and 13, and it has no relevance to the defendant's guilt or innocence of the charges. Right? So again, that they're just trying to block a defense, right? Saying pretty much a minor cannot consent. Duh. All right. It says deliberations. In deciding your verdict, you should not consider the possible punishment for the defendants who are on trial. If you decide that the government has proved a defendant guilty beyond a reasonable doubt, then it would be my job to decide on the appropriate punishment. Once you are all in the jury room, the first thing you should do is choose a foreperson. A foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. You may discuss the case only when all jurors are present. Once you start deliberating, do not communicate about the case on your deliberations with anyone except other members of the jury. You may not communicate with others about the case or your deliberations by any means. This includes oral or written communication, as well as any electronic method of communication, such as telephone, cell phone, smartphone, iPhone, BlackBerry, computer, text messages, instant messaging, the internet, chat rooms, blogs, websites, or services like Facebook, MySpace, LinkedIn, YouTube, Twitter, Google Plus, Instagram, or Snapchat, or any other method of communication. If you need to communicate with me while you are deliberating, send a note through the court security officer. The note should be signed by the foreperson or by one or more members of the jury. To have a complete record of this trial, it is important that you do not communicate with me except by written note. I may have to talk to the lawyers about your message, so it may take me some time to get back to you. You may continue your deliberations while you wait for my answer. Please be advised that that transcripts of trial testimony are not available to you. You must rely on your collective memory of the testimony. If you send me a message, do not include the breakdown of any votes you may have conducted. In other words, do not tell me that you are split 6-6 or 8-4 or whatever your vote happens to be. A verdict form has been prepared for you. You will take this form with you to the jury room. Read the verdict form. When you have reached a unanimous agreement, your foreperson will fill in, date, and sign the verdict form. Each of you will sign it. Advise the court security officer once you have reached a verdict. When you come back to the courtroom, I, the clerk, will read the verdict aloud. The verdict must represent the considered judgment of each juror. Your verdict, whether it is guilty or not guilty, must be unanimous. You should make every reasonable effort to reach a verdict. In doing so, you should consult with each other, express your own views, and listen to your fellow jurors' opinion. Discuss your differences with an open mind. Do not hesitate to re examine your own view and change your opinion if you come to believe it is wrong. But you should not surrender your honest beliefs about the weight or effect of evidence just because of the opinions of your fellow jurors or just so that there can be an unanimous verdict. The 12 of you should give fair and equal consideration to all the evidence. You should deliberate with the goal of reaching an agreement that is consistent with the individual judgment of each juror. You are impartial judges of the facts. Your sole interest is to determine whether the government has proved its case beyond a reasonable doubt. And this is the verdict form. Let me see what they have on it. So they just have guilty and not guilty on it. Let me see if they have approved, not approved. Yep, they just have guilty and not guilty. Okay, and that be it. Coming around the front, coming around the front. Let me see if anything else done hit while I'm in here. Around the front. Let me see if we got anything else. Mm, nope. Okay. So I don't see nothing else. What is this? So, what y'all think? Not that bad. Um, I'll say this because this idiot want to start some crap with me, so I'll take this moment to talk about how dumb they are. I heard some idiot reading the jury instructions, the jury charge, and reading as if the judge was doing something nefarious and unfair and whatever. I'm like, Lord have mercy. Couldn't pronounce the word affidavit or nothing. I'm like, oh my God. Mm-mm. But so that is now it's gonna be up to the judge, right? To it might not go out exactly how the government proposed, like what I just read, but the judge is going to combine, both of the is going to come, del- put it in a way where it would be his wording and his instructions, and so it might not go out exactly like that. Maybe some more added to it, from him. You know what I'm saying? So hey, just give me 1 minute. All right. Thank you for holding, honey. I'm talking. Thank you for holding. Lord have mercy. But yeah, so they will. He will, combine, kind of, piece together both sides jury instructions and deliver one comprehensive one, right? Uh, so you see where the prosecution, see how they trying to play around with the dates? Not trying to play around. I ain't gonna say trying to play around, but they're saying, we really don't have. Maybe in some instances we might not have the exact dates. Like I said, well, if you don't have the exact dates, how you have exact evidence on them dates? There may be some wiggle room for Team Chaos. You know what I mean? So I don't know. Don't know, y'all. Let me see. I'll drop the link just in case somebody wanna keep me up for the next 15. Hey, Purple. Hey, Elvira. Hey, Kobe J. Nicky Ride. Guess DC Radar. I don't know. Say hey and bye. I don't know. I don't know. Hey, Red Bunny. What's good with it? If I switch the words, you're gonna spam the chat. What, Nikki? What? What I do? That was pretty much straightforward. Let me check to see if anything came through while I'm sitting here. I don't even see. I didn't even get that notification. I so happened to was looking for something. So they dropping this shit. Let me see. Okay, so we got that. I read that. And just look. before we get out of here. Well, and let me check with David. I believe Chicago they just gonna get to it. You know what I'm saying? They just gonna be. It's not gonna have a lot of extra. I think it's just gonna be straight, just straight to it. A lot of extra pieces and parts and a whole bunch of um, corroborating evidence and stuff. You know what I'm saying? So, like New York had, because New York had like a piece here, a piece there, a piece here, a piece there, to led up to like a one big situation. I think it's gonna be pretty clean, straight to it. They ain't got all that. Let me see, Milton. I still can't get over that. And took $28,000 from R. Kelly. Like, I'm trying to think, why didn't he move that money? Like, why leave it sitting there? I don't know because once they get behind them bars, Bill Pay, I don't know, like the procedures and stuff with the moving of the money, whatever. Maybe somebody can tell us how that is done. With regards to the inmates, how they move their money and stuff like that. Because I'm just don't see why he would leave that money sitting up there like that. Shit. 28? Mm-mm. Now you got $500. Child, that boy, I'm trying, 100. I'll be somewhere in the clinic, stretched out, with a guy having goddamn chest palpitations, every damn thing. Let me see if anything else. Mm, 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 mm. Jesus. Yeah, I don't see nothing else, y'all. So I ain't gonna. Oh, it just makes you right. Yeah, and I can holler at some. Let me look at some of these comments. Hold on, let me go through. They have no proof that he carried tapes nowhere. It's also been said that he carried money and iPads and backpacks. Yeah, okay. And McDavid's attorney is expecting the government resounded a out Kroll and Darrow. Can't wait to hear that. Yeah. The government responds, yeah. Um, McDavid's attorney is expecting the government to respond about Kroll and Darrow tomorrow. Right. So, listen. If I'm not mistaken, maybe I heard it wrong, but didn't one of those, didn't some of those news outlets, and I don't know if it was the big ones or whatever, but didn't they refer to that whole Angel Kroll and Jim Derogatis exchange or whatever? Then they called the government sneaky or crooked or something. I thought maybe I don't know. Maybe I was listening too hard, but I thought I heard them refer to them as like being crooked underhanded or whatever. And I thought it hit some of the mid to major media outlets that, if they reported on something like that, they found it to be newsworthy, right? And it doesn't paint the government in the best light. That's off the chain. The first They first said Monday, but McDavid guy said Friday. Oh, okay. I think they have to request it and they cut a cashier's check or something. That's how they do, especially when they get out. Oh, okay. Or maybe somebody will tell us how that works, when they have that money on the books like that. Because, like, it seemed like he sat there and let it pile up. Like, now you got $500. Yeah, boy. Mm, 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 mm. Well, y'all, I'm not going to hold you. I just wanted to put this one in the books while I got time. And I am going to go ahead and lay it down. So, once again, make sure y'all like, share, and subscribe. Y'all been doing very good to that. Make sure you like us up. If you don't like me, at least like the chat. Shit, they always, hell, it's interesting. Maybe he didn't know. Do they not get an accountant report? Hell, I don't know. When they get, I don't know too much more when they, you know, get 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 behind there. What goes on or whatever. It ain't like the. Cause I've mainly been on the, you know, on the prosecution side, so it ain't like none of them let me know. Hey, shit, you know, they don't want to talk to me. So, um, so I don't know how that works. I really don't know how that works. Anybody know? Does anybody know how it works? I want to know. What is this? Why is she trying to drop down talking about some Siri? Hold on. I would like to know. Do you remember when they said they could? When they said they could charge him? Charge who? Charge him for being in there. Do you remember when they said they could charge him from being in there? Oh, charge. Oh, talking about charge him money for being in jail. Like they got to pay. He got to pay to stay there. I thought they take that out your work check. Don't give me the line. Like paying rent, right? I thought they take it out your work check. And was going to get that by any means necessary. Hopefully during the September 28th it will be settled. Right. So I need to tell us something because that's we don't know nothing about this here. Now this I can't help. I can't get that information. I can go try to find out, but I don't know how they. But I just don't know how that money would sit up there like that. 'Cause I've always been under the assumption that they could move the um move the money. You understand what I'm saying? Just by request or whatever. That's what I thought. Matter of fact, that's what I thought we figured out, found out. But I don't know. Maybe these BOP people can tell us. Mm-hmm. But don't they make like 11 cents an hour? I don't know, Dynamite. I think it depends on the job. I think it depends on the job. That's how depends. How much they make. I think it depends on the job. But y'all, I appreciate y'all so much. Yeah, thanks again to the hostess, and the guests, and everybody else. And there's another one in the books. Until the next live, peace. Love you. Be easy, y'all. And come back the next time.